Ready? Start. Neither lawyer nor litigant may claim to contradict it except before the judge himself and nowhere else. Stop. The court could not launch an inquiry as to what had transpired in the High Court. Stop. The court is bound to accept the statement of the judges recorded in their judgment as to what transpired in court. Stop. It cannot allow the statement of the judges to be contradicted by statements at the bar or by affidavit and other evidence. Stop. If the judges say in their judgment that something was done, said, or admitted before them, that has to be the last word on the subject. Stop. The principle is well settled that statements of fact as to what transpired at the hearing recorded in the judgment of the court are conclusive of the facts so stated, and no one can contradict such statements by affidavit or other evidence. Stop. If a party thinks that the happenings in court have been wrongly recorded in a judgment, it is incumbent upon the party, while the matter is still fresh in the minds of the judges, to call the attention of the very judges who have made the record to the fact that the statement made with regard to his conduct was a statement that had been made in error. Stop. That is the only way to have the record corrected. Stop. If no such step is taken, the matter must necessarily end there. Stop. Of course, a party may resile and an appellate court may permit him in rare and appropriate cases to resile from a concession on the ground that the concession was made on a wrong appreciation of the law and had led to gross injustice, but he may not call in question the very fact of making the concession as recorded in the judgment. Stop. Thus, the recording of chimney orders by the learned presiding officers is of great importance, as it reflects the proceedings which transpire during the course of hearing. Stop. The learned presiding officers are required to be highly sensitive about recording of the chimney orders, lest it create a new type of litigation in the higher court to deal with, as has happened in this present case, where the petitioner has denied to have taken any date which have been granted by the court below on request, without disclosing as to who had made the request, for the purpose of adjournment at this stage only. Stop.